Good evening and welcome to The Square. Tonight is a very timely discussion. We are going to focus on the new data protection and privacy law. It was recently gazetted just mid this month, and we're going to look at various issues about this law, who it applies to, the compliance period, the compliance time frame, as well as the impact of this law on businesses, as well as private businesses, as well as institutions in Rwanda. I'm happy to welcome with me three of our guests tonight, and I'll start with the gentleman on my right. We have with us here Innocent B. Muhizi, who is the CEO of the Rwanda Information Society Authority. Innocent, great to have you on the show.
Thank you for having me.
You're welcome. Also joining us on the show, we are joined, I think it's his second time on the show, Alain Ndayishimiye, who is the project lead for artificial intelligence and machine learning at the Center for the Fourth Industrial Revolution, Rwanda. Alain, great to have you on the Square once again.
Thanks for having me once again.
Great. And also to give us a legal perspective, very important chunk of the show, and also understanding of this law, we have with us here Edwin Mukiza, who is the legal affairs specialist from the Ministry of ICT and Innovation. Edwin, it's an honor to have you on the show.
Thank you so much, Diana.
Great. My name is Dan MPC, host of The Square. Usually on The Square, I'm joined by my three very vocal resident panelists, Charles Haba and Bernard Namata. Unfortunately, they are away on travel at the moment, but they will be tuning in and also chipping in where they can on our social media feed. So to kick off the conversation, I just want to read a couple of tweets before we start the conversation on this new personal data protection and privacy law. If we can have them on our screens, the first tweet is from Robert Ford, and Robert says that, I am excited to listen to experts discussing this personal data protection and privacy law. More specifically, the instruments the law provides for children data theft and abuse, especially when they are actively engaged online. Bravo. That is a first tweet from Robert Ford. We have another tweet coming in from Fiona Mukashema, who says that we hope to get even more information about how the new law is applied when personal data is mishandled. I guess literacy on personal data protection is a necessity. You're right, Fiona, in terms of literacy on data protection. Our third tweet before we start the conversation is from Bernard, and Bernard says that, does this mean no more WhatsApp in government institution document processing? Also, the communique did not give any specifics. So my question is, what exactly are they doing, and how are they going to enforce those measures? This is exactly why we have our guests with us tonight. They're going to answer your questions. It's an informative discussion tonight, understanding this new privacy and data protection and privacy law. So the first question I have is for you, Innocent. On behalf of RISA, on behalf of government, the newly gazetted Data Protection and Privacy Law aims at safeguarding fundamental rights to privacy by, one, regulating the processing of personal data, providing the individual with rights over their data, and setting up systems of accountability and clear obligations for those who control or undertake the processing of this data. So first of all, if you could just share with us the rationale for this law, the primary goals for this privacy data protection and privacy law.
Thank you, Dana, and once again, it's a pleasure to be here. To just set the context of a data protection and privacy law, data is becoming an asset, becoming a very important asset for that matter globally. Therefore, it is imperative that we make sure that we have instruments that are able to protect that data. Because today, if anything that identifies me can be used against me, I can use it for my own personal development, for my own personal growth. Therefore, it is very important to have instruments, mechanisms, and policies and procedures that are put in place to be able to protect me as a citizen. Protection of personal data is equal to protecting me physically from any harm. So there has to be some legal instruments, there has to be some policies and procedures that are put in place to be able to protect me, because we moved from where we live in on a physical world. Mm-hmm. We now live our lives virtually, if you will. Therefore, we have to have instruments like these ones to be able to protect me as a citizen, as a person, there have to be all these instruments. Therefore, that is the primary and very basic rationale and the tenet of this piece of legislation.
And previously, what was in place? Because a lot of people are asking why now, why not before, what hindered it from being put in place before, what was in place for in terms of absence of this law, what mechanisms were there to protect people's personal data?
So there were other instruments, but these instruments were in different sectors, if you will, or in different facets. For example, if you were transacting in the financial services sector, there was an instrument there that was there to protect you. If you're transacting from a telecom point of view, there are some other instruments that were protecting you. But none of these instruments was looking at a person in his or her entirety. There was no holistic piece of legislation that was looking at a personal data component. But also, none of these instruments was looking at me as an individual or a citizen or as a person living and working in Rwanda, but also who could be able to do business in other countries. And none of these instruments were also looking at how are the businesses or the enterprises or any other entity for that matter that is handling or dealing with my personal data. None of them were looking at how are they treating this piece of legislation. Therefore, there were some instruments, but none of them were holistic, and none of them was really getting down to the basics of how do you define and differentiate my personal data from any other. Because we have to understand there's personal data and non-personal data. So this is really there to protect personal data, because there are other instruments that are going to look at non-personal data.
What's non-personal data, for instance, specifically?
For example, if say we have statistics of GDP growth,
okay,
that's data,
yes,
but it's not personal.
It's not personal. Yes.
But if you're talking about my date of birth,
yes,
that is specific and speaking to me. That is my personal data.
My passport number, my ID number, my medical health records.
Exactly, my medical account
yes,
number that I have,
yes,
the amount of money that I earn, or if I was diagnosed yesterday and I have this particular ailment or something else that is really speaking to me as a person.
As an individual.
As an individual.
Okay. And last question before I head up to our other guests. Who does this law apply to?
So, good question. So the law applies to me as a person, applies to anyone who is going to handle my data, be it a company, be it an individual, be it any enterprise that is going to either collect the data, store the data, process the data, transfer data. So it is looking at all these people who are really, it could be an organization, it could be an individual, any enterprise or any legal entity for that matter, that is processing, handling, or treating data in one way or another. Yeah.
Okay, thank you very much. I would like viewers to just keep the comments coming using #TheSquareRW on our Twitter page and also other social media platforms. My next question before we go to the legal aspects of this data protection and privacy law is to look at Rwanda's competitiveness, especially in the digital economy. And my question to you is, Alain, on behalf of Rwanda's, the Center for the Fourth Industrial Revolution, is how does the law build Rwanda's competitiveness in the digital economy, and what benefits does it provide? And here it's to just educate the public on the importance, the benefits of this law, and how it puts us out there in the world as a country.
Sure. Thank you for the question. Just to emphasize what my colleague Innocent mentioned, the new law talks about personal data. As we all know right now, data is considered as a new oil, and to most countries it's an asset. I will answer this question under 2 points. The first being the possibility for sharing and transfer of data, and the other one being consumer confidence. The first one, in terms of sharing and transfer of data, Article 48 of the law allows the sharing and transfer of data across borders, and this is done after the authorization of the supervisory authority. What this means is that we're enabling the free-flow data, which enables or facilitates knowledge sharing, as well as collaboration that push forwards for digital innovations and also the development in terms of the economy. Maybe just to elaborate on that, I can give you a few points in terms of the economic impact of the law. The law, again, is intended to protect the privacy and also push for the protection of this data. And this also gives the environment through which innovation can happen, especially if we're talking about exchange of data. This brings about new products and services, digital products and services that enable the creation of things such as jobs around these services, but also the opportunities in terms of the markets that these new products and services around this data protection can avail. Another one, it also positioned Rwanda in terms of strengthening its position in international trade and negotiations. Here, if we're allowing data to be exchanged globally, now we have insights into new markets data that we can leverage to promote or push forward our digital and economic agendas. We're also looking into things such as innovation, especially this is good news for the innovators out here that really were facing a challenge of how do we leverage foreign infrastructures such as the AWSs and the Googles alike for things such as artificial intelligence and other emerging technologies. What this law does, it now gives opportunities for young innovators, even developers that are on the market, to leverage some of these infrastructures that we don't yet have on the market, on the ground that we're actually planning to put in place. Lastly, it also, it's not first of its kind. This law is benchmarks on international best practices and laws in terms of regulating data, privacy and protection. And what this means, it's providing a conducive regulatory environment that brings the appetite for any investor or international or foreign data-related technology company to come and invest in the country. This is due to the adequacy levels that we think this law has that are almost similar to what's out there, like that we benchmarked on, such as the GDPR, the Malabo Conventions, and the others alike. In terms of the consumer confidence, here we're talking about the law being an instrument that builds trust between the consumer and the data processors and the data controllers. What this does, again, it's opening up doors for innovation and the creation of new opportunities in terms of, if we're talking about SMEs, these are new market opportunities for services in the e-commerce area. These are services, opportunity for services and products that we can also export outside the country. So those are just few of the highlights of the law and how it can affect or impact us in terms of our economic journey and agenda. Thank you.
And as a country, just a follow-up question, as a country, in terms of implementing the full-scale implementation of this law, are we ready? Do we have the necessary governance frameworks to enable the actual implementation of this law? Because it's not a standalone, it needs various support systems or governance frameworks for implementation. So
this law is actually built on other laws that were in place and policies that already support the law as it stands. But the last article of the law, which probably my colleague will touch on, talks about a grace period of 2 years when the law comes into effect. What this 2-year time frame provides anybody that's wanting to process or wanting to enter the processing business, it gives them the time to ensure that they are compliant with the law, but beyond that also ensures that they have registered with the supervisory authority, who is the authority in charge of ensuring that this law is in compliance. And beyond that, this 2-year time frame is also a time for all stakeholders involved to bring about their awareness around the law, especially trying to educate the citizens about their rights when it comes to data, and also making sure that we are giving solutions to some of the challenges in terms of implementation, given that this law is still a new law.
Okay.
So maybe,
yes, sure.
If I can add on that one, and basically starting even from the very first question. For example, we know, and this is what the country is doing, trying to attract investors to come here. So the absence of a law like this creates a vacuum.
Absolutely.
Where there are some companies that are going to say, look, if I'm an European company, an American company, a Chinese or a Canadian company, I want to set up in Rwanda or I want to come and invest in Rwanda. And I don't see any business right now that does not involve some form or shape of personal data processing,
Yes.
it is going to be an inhibitor for them to come and set up here in Rwanda. So that's on the first question that you asked. On the second question, Ali just mentioned it. We have a transition period of 2 years. We don't have all the instruments, all the legal instrument is there, but we need procedures, we need processes, we need really to define. And this is the time frame that has been given for 2 years for everybody who is involved in data processing, collection, what have you, to get ready. There's going to be a campaign, an awareness campaign, to educate citizens, so to speak, as the very first primary beneficiaries of this legislation. They really need to understand and say, what does actually this mean for me as a citizen? We either a Rwandan citizen or any citizen of any country that lives in Rwanda, anyone who lives in Rwanda, works in Rwanda. So they really need to understand that. Number two, the businesses that operate and work in Rwanda that are processing or managing personal data. This is a good time for them really to understand what does it require them to do, what sort of investments are needed, and that's why a 2-year period was given to really allow them ample time for them to get ready, so that when the compliance period kicks in, then they have gotten enough time to really get ready.
Okay, interesting. I would like to go to the legal aspect of this law. Edwin, this is why you're here. The legal implications, especially with regards to do with compliance and time frame. Innocent and Allah have indicated it's a 24 month process in terms of the time frame to implement it. So if you could just take us through this time frame and what planned procedures are in place to ensure compliance amongst businesses and institutions. So it's really looking at the next 2 years. Just take us through the steps to ensure the full implementation of this law.
Yeah, thank you, Diana. I think this is also part of the implementation. We are now at an awareness phase.
Absolutely.
Yeah, the second step I think will be, but an awareness, I mean, we keep going on with the awareness. It's not going to end here. It's a long process in the grace period of 2 years, transition period. But we also work with the other institutions, stakeholders, to make sure that this awareness is conducted. I mean, it becomes effective, that each an individual person, a Rwandan, or even a resident, a non-Rwandan, a non-national, can get to be aware of all of this law, because this is a new practice, this is a new law. We have been having these laws globally. You have the GDPR, you have, I mean, some even African countries have developed these kind of frameworks, cybersecurity and data protection framework, but this is a new practice. We have been having separate laws with some aspects of personal data, but basically, it's not a general, we cannot say that we have been having a general data protection law. So the first phase will be awareness. The second phase will be working with stakeholders, institutions. The people we call data controllers and data processors. Yes, they have been working for a long period. The question maybe would be how were they working? We've been having different legal tools already in place. We have the law of contract. They have been processing data through contracts with the service seekers. I can give you an example of maybe telecom companies, banking institutions, and so many others. Business processing, outsourcing, what we call BPOs. So they've been working through contracts. But now, we're now coming at a phase where we need to have a law that combines all those practices. Going back to your point, to your question. the law provides different instruments. They are executing regulations in the law. People will have to register with the supervisory authority, which is now the National Cybersecurity Authority. So there will be time, I think the National Cybersecurity Authority will issue guidelines on how people will be registering. I don't think we need to wait for the 2 years to come to an end. Some of the data controllers and data processors would like maybe to register at the early stage. But allow me to reserve on this question because the question looks managerial. There are competent people who can answer this. Mm-hmm. Yeah, that's what I can say.
Okay, thank you. Yes, it may be managerial, but I think in the interest of the public, they would like to understand, the process. But yeah, you've given us an idea in terms of the stakeholders that you will be working with, the 2-year period, the sort of companies that, or institutions that will be called, to register and that sort of thing. So thank you for that. I had a question in mind in terms of, and I don't know, maybe it's too early, maybe it's a bit too premature to ask, but in terms of compliance, what are the sort of repercussions, or what do you envision as data breaches when it comes to this privacy, data protection and privacy law? So first, what would be incidences, for example, of data breaches by, like Innocent said, these institutions that are handling data, this is primarily who they apply to. And second of all, what would be the sort of repercussions to elements of data breaches caused by non-compliance by these institutions to this law?
Yes, we can expect some repercussions, but this is also, we cannot say that maybe this is a particular situation to Rwanda, because if you look at the European Union, the GDPR also provided 2 years transition period, which means they're expecting a lot to be done within the 2 years transition period. People, first of all, need to understand what is data protection, what is all about. The first is understanding and adhering to the requirement of a data protection law, because there are lots to be done. There are technical requirements to be put in place. Well, maybe some of these institutions, some of these data controllers and data processors have been having infrastructures and other requirements, but I'm not very sure if these requirements were sufficient enough as required by this law. So a lot will be required by the people who have been processing data. But indeed, the 2 years period, we think, is enough for them to put all necessary with the technical requirements or other resources, including people who will be managing data, personal data. In the law, we have a person called Personal Data Protection Officer, that each institution will be having a personal data protection officer. So it's a process. It requires resources. You cannot hire when you don't have resources. So there is finance part and also a technical part of it, of which I think it will be a little bit a challenge. But it won't be a challenge because even the transition period is enough for them to put in place the requirements. I think that's one. But two, the institution itself, the supervisory authority, I think it needs enough time to prepare all those executing legal tools. And well, I'm not very sure because I'm not speaking from NCSA, but I think they are now working hard to make sure that this law is effectively implemented. I think those are among the few things that we can expect because it's a new situation in Rwanda that need to be given time to prepare all those tools like what I've mentioned.
Thank you very much. Edwin. Innocent, you want to weigh in?
Yes. You asked a question, for example, what would constitute something like a non-compliance or a breach, or something like that. For example, if you look at Article 20, which talks about the right of personal data portability, right? And actually, if I can just read it, the data subject has the right to request the data controller in writing or electronically to resend the personal data concerning him or her as it was provided to the data controller in a structured and readable format. For example, if I am the data subject and I say, you are the data controller, I need you to
So for instance, let's say you're a patient and this is a hospital.
Exactly.
Just to put it in layman's terms for our viewers. Yes.
So if I say that I've gone to the hospital and I say, okay, can you send my data and send it here in a readable format or state? And then if it is not done, or for whatever reason, if maybe that hospital says, no, I cannot send this data of this patient, maybe we're going to lose a customer, something like that. It is my right. So the failure of that particular institution or the hospital to send my data,
your personal data,
my personal data, to another hospital or to another organization, that constitutes a breach. And the piece of legislation provides instruments in which now how that organization is going to be dealt with. So there are quite a number of those that are in there, but there are others maybe that will be defined as we go forward. But the legislation covers in its entirety all these sort of breaches that can be committed by anyone. For example, it says that every data controller or processor has to be registered. So if you process any personal data of any citizen and you're not registered, you've not been certified or given that right to do that, then already you're in breach. And when you look at, I think, if I'm not mistaken, I think it's chapter 9 that talks about 8 or 9, the conduct in which how if you've breached any of the articles, how you're going to be dealt with in terms of the legal provisions.
And just also, for my sake, but also our viewers, the authority, the institution that will be driving forward this law and implementation is the National Cybersecurity Authority?
Yes.
Okay. So
maybe to give a context here, and maybe to also give a genesis of how the law, the drafting and the process of drafting the legislation. National Cybersecurity Authority is a new institution and is taking on and still is driving this mandate, and they are going to be the custodians and the implementers of the law. So right now they're working very hard on preparing actually the awareness campaign, all the legal frameworks that are going to be used, all the other legal tools. For example, if you're going to register, where do you register? How do you register? What are the processes? So they are working very hard to prepare this, and I believe there's going to be a formal launch where they are going to invite all different stakeholders, really to sensitize them on how the law impacts them in one way or another. So in the process, when we're drafting the law, it was started, of course, with the Minister of ICT and Innovation and RISA. We consulted, of course, organizations like RURA, and then Center for Fourth Industrial Revolution came and supported us in the process. And we had so many iterative consultations. Started off with looking at the laws around. For example, the Malabo Convention law that talks about cybersecurity. We looked at GDPR. We looked at laws of other different countries, Mauritius, Kenya, Ghana, South Africa, United States, UK, and so many others. And we even shared this with the academia. We had consultations with academia, we had consultations with other private organizations like the banking sector, the telecom sector, and we even went further abroad and really consulted even multinational corporations like IBM, MasterCard, so many organizations, Microsoft, so that we make sure that the law that is going to come out, one, is comprehensive enough to be able to cater for interest of different parties, individuals, enterprises, and organizations, and also speaks to what the vision of the country is. If you want to be an investment destination, how does this law actually go along that line to really entice and become an attraction point for investors? Because if they come and say we're going to invest in Rwanda, let's say we have legal instruments that are going to protect their investments. So yes, back to the question. No, this is a long way to answer the question.
No, but I'm glad you also, my next question was like, give us the genesis. How did it emerge? And I think you've adequately given us, some context.
Yes. So basically, the National Cybersecurity Authority will be driving it. So for us, actually, a majority of us are beneficiaries, and we are actually going to be looked at. NCSA is going to come and say, okay, what have you done? Are you ready? Do you have all the steps catered for? So they're working very hard to prepare that, and I believe they'll have an event where they can be able to engage everybody and have people bring in their inputs in how the implementation of the legislation can be done.
Okay. Yeah. I would like to go to Alain. You're here as a project lead for artificial intelligence and machine learning. And I want to look at this law also in some context whereby, like you said earlier, in terms of competitiveness on the digital economy, as a country, Rwanda, do we have sort of massive amounts of data, especially to do, for instance, with artificial intelligence, where this law would benefit us? I'm trying to look at activities in Rwanda that correspond to the relevance of this law. If you could just give us an idea.
Sure. Yes, we do have a lot of data, but the way the data is stored is in silos. So this data is unstructured, and it's in formats that are not ready to be consumed by these technologies. So the biggest challenge is going to be how do we organize the data in a way that it's ready to be deployed and consumable in terms of AI and or machine learning algorithms. So the law, again, like my colleagues mentioned, is in reference to personal data. And we have identified a couple sectors that actually would benefit more than others in terms of the law. And this includes the financial sector, the healthcare sector, the agricultural sector, just to name a few. And these all actually have a lot of data that already exists, but how do we actually start now harvesting this data for the good of these technologies? So what this law does, especially, I'll give you use cases, especially for like healthcare sector, where the data is mostly sensitive data. We're talking about data that you wouldn't want to share with anybody. How do we ensure that if that happens, it's not identifiable in a sense? So here we're looking at the law giving us the opportunity to actually mask some of this information so that it can be used for scientific researches, can be used for diagnosis, for example, and so on. Just a quick example, there's a startup company here in Rwanda that actually was facing a similar challenge by Insightive. They have a medical image diagnosis tool, and they had two challenges. One is how do we get the access to the data, because this is sensitive data that we're talking about medical records and so on, but also how do we also access the infrastructure that's needed to power these technologies. So what this law does, it gives the flexibility to allow both to happen. We're talking about pseudonymization of the data, or putting it in a way that is not readable by human eye, but can be translated on the other end for the purpose it's intended for. In terms of also access to the infrastructure that's needed, how do we push this data maybe to the cloud, where we have the computing power capable to process this data. So again, this goes back to the article I mentioned about sharing of data. This will allow these innovators to actually leverage some of these foreign companies to make that happen. So the data does exist, but it's in silos and it's in formats that are not yet ready to be consumed. And you find that a lot of the records we have, they're in written records.
Written formats.
Yeah.
Yes.
So how do you also translate that into digital formats that can be consumed by these technologies?
Okay, thank you. Before we go to a Twitter feed, there are lots of tweets coming in. I would like to go to Edwin, based on what your fellow panelists have said. Is there something you'd like to add in terms of what they've said, especially with regards to the law itself?
Yeah, thank you so much, Diana. Maybe one thing that is special with our data protection law is that we looked at the best benchmark, because because the main objective of the data protection law is not only to safeguard people's privacy, but we're also looking at the investment perspective of it. The reason why we're trying to work with other countries, other states, through we have different international legal instruments. CEO Innocent mentioned the Malabo Convention, but we still have a lot of things to do to make sure that we cooperate not only at continental level, at African continental level, because Malabo Convention is an African Union Convention on cybersecurity and personal data protection. But we still have to cooperate with the European Union. Mm-hmm. We are now focusing on Budapest Convention. Budapest Convention is the European Union Convention on cybersecurity, but it also has an aspect of data protection, but mainly computer data. It is also open for accession for whoever wants to access Budapest and become a party to the Budapest Convention. Some African countries like South Africa, Nigeria, Guinea, Mauritius, are already members to the European Union GDPR. So we have technically started looking at it, looking at the feasibility for Rwanda, if maybe the government can. But this is political, so it's I'm speaking from technical perspective, but not. Allow me to reserve on a way forward here. But technically, I think we still have a lot of things to do. We still have to work with the other international organizations. We are already a member to the OECD, Organization for Economic Development and Cooperation, which is also a precedent to the European Union cybersecurity protection, the Budapest Convention. Mm-hmm. We also are party to the United Nations Convention on the Rights of Children. We already have child online policy in place. We've been conducting awareness to let people know the rights of children. The country is now moving towards digital economy, but also, which is also risky because today, I think it's not even rare to find a child below 16 having a phone. Free to use electronic devices, and which is also exposure to all those risks. So I think you have a lot of things to do. But good enough, we have done a lot. We are a party to the African Continental Free Trade Area, which also requires Rwanda and other members to have data protection tools in place. So we are lucky that I think in East Africa we are the third. Kenya, Uganda already have these tools in place. Tanzania, I'm not very sure, and even Burundi. So we are lucky that we have that tool in place and at the early stages, but this is not enough. We need to cooperate globally because these crimes are cross-border crimes that without cooperation with other states, exactly. I don't think the country can achieve anything.
Absolutely, especially on the part of collaboration. And I like the fact that, all three of you are mentioning that, this law enables, the implementation to happen without it being in silos, which was what was happening before. You mentioned, the child protection policy. I think that also probably answers Robert Ford's question on how the law will prevent will protect children online. There's already a child protection policy, but now that it's part of this law, you've brought everything together so they're not isolated incidences of policy and mechanisms. I'd like us to just go to our Twitter space. We have some interesting interventions. We have a few minutes left, but I'd like to read these tweets. The first one is from Dolapo, and he says that as it is known, data is the new currency and a goldmine for countries and companies in the 21st century. And personal data protection is key in giving confidence to citizens whose data is handled by appropriate authorities. We go on to his next tweet, and his next tweet says that it's a question. He asks, and I'll leave this to the entire panel, does this instrument protect citizens from companies, businesses who would be synonymous for sending unsolicited commercial text messages and who might lean towards purchasing large data from businesses who daily have access to personal data? Good question. This was also one of the questions on my mind, similar to how metadata is exchanged by all these huge social media companies. How will this work in Rwanda? His other question is how would the instrument be able to regulate those who handle personal data who are not in government parastatals? For example, private businesses where citizens can only access only after name, number, and location have been written down. For instance, Vuba Vuba, for instance. What determines a data processor? So those are his two tweets. And then his third tweet, he says that an interesting topic on personal data protection and privacy law on the Square. The Baltic state of Estonia is a perfect case study on personal data protection and all its ramifications. So first question, Innocent, Alain, and Edwin, on how do you regulate businesses that are not government parastatals? The second, how do you protect consumers for information, whereby some institutions may be obliged to sell that data or give it out to various other companies for different reasons?
Thank you. Let me start off with actually the second question. I think it's the second or first. I can't remember. The one of the unsolicited messages. Yes. There are actually already instruments that provide how that can be addressed. For example, RURA has a process in which if any organization, telecom or whatever, sends unsolicited messages, there are sanctions to that. There are actually instruments in place already addressing that. So that actually, leave alone the personal data protection and privacy law, there's already actually another instrument that addresses that. On the second question of organizations that are not necessarily government parastatals, and this is actually what I explained a little earlier. The law is not only for government institutions, it's for any organization or any person in Rwanda and outside Rwanda who processes or handles personal data of any person who lives in Rwanda. So Amazon Web Services that lives or operates in the United States or whatever, if they are processing personal data of any person who lives in Rwanda, then this piece of legislation applies to them as well. So I think it just provides clarity that the law does not only look at government parastatals, it also looks at private companies, private individuals, if they are handling and processing personal data.
Interesting.
Just to maybe to add on to what Innocent mentioned. So the law talks about purpose limitation. So when these companies are collecting your data, they need to specify what the data is going to be used for and how long they're going to use it for. If it goes beyond, then it's an offense. So once they're done using the data for the purpose of whatever the data was intended for, they're supposed to either discard it or store it in a way that is safe, that doesn't go beyond the purpose that it was intended for. So if you have consented for your, maybe a data to be used maybe for a particular ad, and you find that it has been used somewhere else for other commercial purposes, then that's an offense on whoever has processed the data. So the data should be processed in a way that it has a purpose, but it also has a limitation to what the data is going to be used for. Unless there's also special cases, maybe within the national interest, maybe for scientific research, or example, in the case of COVID, maybe your data may be needed for maybe tracking and so on for the spread of COVID and so on. So there's purpose limitation. And back to what Innocent also said about the law applying to any individual or companies, regardless of their geographical location, that process the data of Rwandan residents. This also also guarantees the right to privacy that is determined by Article 23 of the Rwandan Constitution of it being a right. So it emphasizes that aspect of, hey, it's your right that your data should be protected. It's your right that it should be processed in a way that you consent to. And beyond that as well, it also gives the confidence and the trust that's needed that whoever is handling my data is using it for whatever I've agreed to. So I just wanted to throw that in there.
And then just last, the question that Dolapo asked, like, what determines a data processor?
So what determines a data processor? So anybody who actually processes data.
Okay.
Again, be it an individual or an entity of some sort. But there's a criteria that are set within the law that whoever wants to be a processor needs to conform to. So that's the job of the supervisory authority to register these people. So if you're in your small startup, whatever you are, and you think that just because you're small, you can process data, you're considered, this law applies to you regardless. If it's an individual, if it's an institution, whatever size and whatever part of the world you are in, and as long as you're processing data of Rwandan residents. So a data processor is anybody that's processing data of a data subject. And there's principles within the law that allow you to do that, the safeguards. And what this law also does, it gives, it's designed in a way that it gives the Rwandans and whoever is the data subject more control over their data. So now you'll be able to say, hey, I agree, you can use my data, you can use it for these X purposes, but you can also go back and say, I don't want you to use it anymore, I want you to destroy it, or I want you, like Innocent had mentioned, to move it from maybe from one data processor to another, maybe on Facebook, and you want to go to a different platform, for example, you'll be able to do that by using this instrument.
Okay.
So maybe to add on that, if you go into the law and you look at Article 3, which is about definitions, and point number 24 actually defines who a data processor is as any natural person, a public or private entity, or a corporate body or legal entity which is authorized to process personal data on behalf of a data controller, and also defines who a data controller is. So if I would encourage people to look at the part, Article 3 of the definition of that. And I think it would be unfair to Robert if we did not respond to the, I think it's actually Article 9, which provides how the law protects the children, because it specifies how if you're going to process data for a child that is under 16, you need to get a consent of the guardian of that child. So Article 9 really defines that and provides guidance on how children's data is going to be protected.
I think it's also very important for people to also familiarize themselves with this law. That said, I would like to hear from you, Edwin, on some of the tweets that have come in. But my question is also, you know, Rwanda, where can we find this law? I know you're going to do an awareness campaign that you're going to roll out for 2 years, but currently, is it on websites? Have you kickstarted this process? If I wanted to find out more about this law and I'm a data processor, where can I go? How can I access this information?
Yeah, thank you, Diana. The law is accessible. It's available on our website, on the ministry's website. It's also available if you go to Ministry of Justice. There is an office responsible to handle all those kind of issues. I mean, official gazettes. So, but we usually also find them on, I mean, through Google. I think I've never tried it, but if you go to Google, maybe you can find it. I don't know how maybe Innocent and some other technicians know how long it takes to put something on a Google. I was surprised to find my photo. Someone took my photo through the Google, and I think the one we saw on the advert, it was my second choice. The first choice was taken.
Wow.
But it wasn't my willing, so I don't know how. And that's actually, it's a data breach, by the way, because having an account without opening it to the public whatever techniques you can use without my consent, then it is a data breach. It can also be a cybercrime. So people should be careful by looking at maybe Diana's picture through whatever, through any platform. Doesn't mean unless or until you expose it yourself, you open it yourself. Because you have accounts, we do close our accounts, but people still get our data. So the same thing applies to, I don't know how Google works, but it's possible you can find it through Google, but two websites, Ministry of Justice and the Ministry of ICT.
Okay. Yeah, I really like, Edwin, how you mentioned, you know, the picture that we put for the flyer today on social media. You know, we put your picture, we put your picture, we put Edwin's picture. He had no idea that picture existed online. And it's kind of like, you know, there are times, if you go and type in your name and you find very weird, not weird, but you have pictures on Google that you thought were private because on Facebook, your account is private. It's not open to the public. So I think it's important to also explain this. And I really look forward to the awareness campaign. Happy to be part of it as well, just to break it down, demystify it in very understandable, not so much jargon ways to the general public. You know, sort of these real-life examples with social media, real-life examples with hospital medical records, that sort of thing. I'm really looking forward to how it will be rolled out as a law and people, you know, consuming this information in a way that's easily understandable to them. We're coming to the end of the show. I'd just like to give closing remarks, if you can be brief as possible. I can't believe all these minutes have flown by on such a technical issue, but it's a very interesting topic. Innocent, closing remarks, what would you like the public to remain with here? People who are watching the show, who are engaging on social media, you know, from their homes. Closing remarks moving forward with regards to this law.
Number one, I'd like to encourage everybody, every citizen, whether Rwandan or non-Rwandan living here or anywhere else, to, number one, understand that data is very important. Therefore, they really need to start recognize that data, especially their personal data, is very important. They need to treat it as a gold mine or oil or something. I don't know who mentioned it. Number two, I would like to encourage people to go out and check on the Ministry of Justice website where the law is published, Ministry of ICT and Innovation, RISA website, National Cyber Security Authority website. So the law is there to read it, understand it, internalize it, and make sure that you really understand what it says. Number three, people should not panic or should not get afraid. Rather, they should be excited, because this is a piece of legislation that is really opening up opportunities and doors for not only private individuals, but private organizations, government institutions, and even other people are doing research. So this is a good tool that is going to go a long way in enabling us to really achieve all our intended objectives, whether social, private, business, or otherwise. So I really encourage people to read it. And just want to close by saying that get ready. National Cyber Security Agency that is leading the implementation of the law are going to organize different events, different engagements, and we really need to jump on this bandwagon, really make sure that we understand it, so that when the 2-year comes to an end, everybody is compliant and everybody is very conversant with what it requires and what they ought to be doing.
Thank you very much, Innocent. It's been a pleasure having you on the show.
Pleasure,
very solid submissions. Thank you. Much appreciated.
Thank you.
Closing remarks from you, Alain?
Mine, just to echo what Innocent just mentioned, they shouldn't look at this law in terms of panic, but look at the economic benefits that this law is going to bring, especially if we're talking about moving to the fourth industrial revolution. We're in a competitive world where those that control the data, those that protect the data will benefit more than others. So having this law in place is an advantage for us as a nation. in terms of the global competitiveness, in terms of the opportunities that this law brings, and also encourage, like Innocent mentioned, people to go out and actually see questions and get responses. This 2-year period, that's why it's there, this transitional period. It's a time for everybody to understand what the law means. It's a time to understand how it applies to them as a business or institutions, regardless of size or whatever part of the world you are, as long as you're processing random data.
Thank you. Closing remarks, over to you, Edwin, very briefly.
Yeah, thank you so much. I can close it maybe in one line by saying that data protection, personal data protection is the only solution to data subjects' privacy, no any other way.
Thank you. I love it. Succinct, short, sweet, to the point. It is the only solution to data subjects, data privacy protection. Thank you very much, Innocent. It's been great to have you on the show. Thank you very much to Edwin. Thank you very much to you, Alain. To our viewers, please keep the conversation going using #TheSquareRW. To our partners, Uzi Collections and Bourbon Coffee, thank you for always supporting The Square. Have a good night. See you again next week.